While advancements in IVF technology have helped many to start a family, who decides what happens to unused frozen genetic material if a couple separates? Child custody battles have been getting very messy. Frozen embryos often being used as bargaining chips in divorce settlements. Stephen Page is the principal at Page Provan Family and Fertility Lawyers. That is a very specialist field, Stephen.
Well, I've been a family lawyer forever, but I've done fertility law also forever.
What does happen to frozen embryos if a couple split up?
Well, the starting point is, what form did they sign with the IVF clinic? In the old days, the forms would say, if we split up, then donate to research, or we'll work it out between ourselves like a court order or agreement, or discard them. And the problem with the old forms was often the box wasn't ticked, or they didn't sign, because I've seen forms like that. So typically with clinics these days, the forms say, if you split up, let us know, and then you two work it out what's to happen with them.
There is no legislation covering this.
Well, not specifically, but what's happened over time is that the family court has got involved, and there's been a very small number of cases in the family court. And the most recent was a judgment I got just before Christmas, where the court found that the embryo, singular, was property, and therefore capable of being the subject of property settlement. Now that's pretty important, because what previously happened, the previous major decision was that you could have an injunction. So the court could restrain or empower a party to do something with the embryo. The problem about that approach is that you had to file in court, you had to go before a judge, so it was slow and expensive. And where parties are in agreement, the usual way that you'd resolve a property settlement is to have consent orders made by a registrar, so quick, cheap, simple, or to have a binding financial agreement. And if an embryo isn't property, then registrars were refusing to make orders because they said, we don't have jurisdiction, we can't make injunctions, only judges can make injunctions, and it was doubtful whether they'd be the subject of a financial agreement. So having this recent judgment makes it a lot easier to say to registrars, you've got the power to do it, and therefore make it quick, simple and cheap to resolve.
Do you think it will be quick, simple and cheap? Will people take that option, or are embryos being used as bargaining chips?
Well, they certainly have been used as bargaining chips, but I've been surprised at the number of times where parties have reached agreement about the use of embryos, and I've drafted contracts so that it's clear for the IVF clinic what's happening with the embryos. The fear by those who've got their genetic material is often, after today, if a child comes along, I'll be a legal parent and therefore liable for 18 years of child support.
Right.
And if you're careful with the whole process, then that doesn't happen. And about a year or so ago, I was called in by a colleague who was acting for the wife, who wanted to use the embryo, which was both her and her husband's, her egg and her husband's sperm. And the husband's lawyer was saying, no.
And they had separated?
Yeah, they'd separated. And so they were dealing with property matters. And the thing that was holding everything up was this issue about the embryo, because he was afraid he'd have to pay child support.
And would he have had to?
No. Well, what happened was I was engaged just on that issue, and I wrote a very, very long letter for the benefit of both the lawyers to say, look, nothing to see here, he won't be a parent and this is why. And that broke the logjam. They were able to reach agreement, and as a result, I hope she was able to use the embryos and become a mum.
This is ABC Radio. My name is Kathy Schnitzling, and my guest in the studio is Stephen Page, who is a family and fertility lawyer. When people enter into an IVF process with a clinic, do the contracts cover what happens to the embryo should a parent die?
Yeah, it typically does, and it will talk about posthumous use. It's funny, only yesterday I had a couple give me one of these forms from a clinic, and it was really good to see they've got to make a decision about whether there's going to be posthumous use. But posthumous use is a tricky thing because sadly, we don't have national laws concerning posthumous use or IVF in Australia. It's each state has its own rules. So it's okay here in Queensland, you can do it. Trickier, and okay also in the ACT and Tasmania, but trickier everywhere else. And in Western Australia, forget it. So recently there was a story in Western Australia of a 62-year-old woman.
That's right, yeah.
Who was widowed, and she got an order from the Supreme Court that enabled the retrieval of sperm. Most of the time you don't have to go to court. You just go through a hospital process. There's legislation talking about retrieval. But the court was critical that the relevant officer of the hospital wasn't there. You know, they were missing in action. So she had to go to court to get it done. But she won't be able to use it in Western Australia because posthumous use can't happen there. So what we find is that widows in much of Australia come to either Canberra or Brisbane and Gold Coast for posthumous use because it's available in both places.
This is so complicated, Stephen.
Well, yes, it is. But, it's one of the things that I help steer people through. It's unbelievably complicated and I think unnecessarily so. It'd be a good idea if there were actually national laws on this.
Yeah, instead of a whole grab bag of different ones. If a couple do go through the process and they have frozen embryos and they don't use them at all and they split up, what then happens to the embryos?
Well, the first thing is that they've got to pay ongoing storage fees, and they happen every year. The clinics are happy to put their hands out and say, hey, listen, we've got to pay for the electricity for this and the audit requirements and so on. So we've got a charge. And if they don't continue to pay that, then ultimately the clinic will be in contact with them and say, hey, listen, you haven't been in contact for however long. We're thinking we might discard. And that obviously clinics are most reluctant to discard in those circumstances in case the person says, well, actually, I was ill and I didn't know, and now I'm going to sue you because you got rid of my embryos. But there is a time limit on how long they can stay. And it varies state by state again, but in Queensland it's seen as a reasonable time limit, typically about 10 years.
And other states would be similar?
Yeah, 10 years is about the norm.
Okay. What are the ethical considerations, say, at the end of that 10 years, the embryos aren't used, what happens to them?
Well, typically, if there isn't a consent for donation or for scientific research, then they will be discarded. And there's a process that the clinic goes through to make sure that that's done properly.
And that is state law as well, is it?
That's, yes, it varies on state law. And in Queensland, we don't have specific laws on this. If you run an IVF clinic in Queensland or anywhere in Australia, you must have a licence from the Fertility Society of Australia and New Zealand. Federal and state laws say that. I'm a director of the society, but I'm not speaking for the society on that. But once you've got that licence, you then must comply with the society's code of practice, which then requires compliance with the National Health and Medical Research Council's ethical guidelines. I won't give you the full name, it's far too long. But the effect of that is, here are these licensing conditions imposed in effect by the NHMRC, and they have a process for disposal.
Is surrogacy legal in Australia?
Everywhere. I wrote a book about when, not if, surrogacy for Australians, and as soon as I wrote it, of course, the Northern Territory laws came in and made my book slightly out of date, because the Northern Territory had been the holdout forever. And it was a joy to be part of the Northern Territory government's process to have those laws in place. But everywhere in Australia, we have surrogacy laws that enable altruistic but not commercial surrogacy. Sadly, they're not consistent. And
surprise.
Surprise. This is the message of the day, isn't it? And we had a House of Representatives inquiry back in 2016. George Christensen, of all people, chaired it, and he called for national non-discriminatory surrogacy laws. We're still waiting.
I was going to say, and what happened after that, Stephen?
Well, we're still waiting. And the good news is that there is very slow progress. And currently the ACT and Western Australia are reviewing their surrogacy laws. There's a bill before the ACT Legislative Assembly, and the WA government is looking at having laws in place this year as well, updating.
And what will change?
Well, incremental is the way I describe it. But the overall scheme of things, which is to allow altruistic surrogacy but not to have commercial surrogacy will remain. But discrimination that currently exists in the ACT that requires a couple to undertake surrogacy and the surrogate to be part of a couple, that'll go. The ability to have traditional surrogacy in the ACT, which is the surrogate being the genetic mother, that will be allowed. And the ACT won't restrict IVF to just occurring in the ACT. In other words, you can go, well, I don't know, to Sydney or the Gold Coast and do it. And WA, there's discrimination currently against single men and gay couples undertaking surrogacy, and who knows how non-binary or transgender or intersex people fit into the mix, because you've got to be a heterosexual couple or a single woman or a lesbian couple to undertake surrogacy in WA.
What about embryo donation? Donating eggs. That's legal, isn't it?
Yes, you can donate eggs. The issue that we had under Commonwealth and state and territory laws nationwide is it's got to be altruistic. And so as a result, surprise, surprise, we have a shortage. And so we find Australians going in great numbers overseas to access donor eggs. We now find in recent years that Australian IVF clinics are importing donor eggs from overseas, typically from the US and Ukraine.
I did not know that. That is amazing. It blows my mind. It's so complicated.
It's extraordinarily complicated. And I just wish that we had national laws in this area. For about 5 years, I taught ethics and the law at the University of New South Wales and reproductive medicine. And all my students were typically working in IVF clinics. They said, "How come there are no national laws?" And I said, "I don't know. I'm just, I'm the monkey, not the organ grinder. I'm just the guy who's giving the message." But it just doesn't make sense. We have the population of Shanghai, and we have 9 systems of law governing this area. We should just have one.
Because it is a fairly universal subject, creating a family, right?
Absolutely. And the other feature about IVF in Australia is that the industry is remarkably concentrated. There are about 5 or 6 national clinics. And so they go across borders within Australia, and they have to comply with the different rules in each state. What does that do? That, in effect, increases
the cost.
And who pays for that cost? Well, the patients, of course.
The patients do pay. Stephen Page, thank you very much for joining us here on ABC Radio.
Thanks, Kathy.
Stephen Page is the principal at Page Provan Family and Fertility Lawyers, and I do not envy him his job. That sounds incredibly complicated. The things and the lengths that people will go to and the obstacles and hurdles that they face to create a family.